and gentlemen. My name is Chang, and my English name is Amy. Feel free to just call me Amy. I'm an assistant design patent examiner, and it's my honor to be here to introduce you to the patent regime in Taiwan. In follow-up sections, there are workshops you can discuss more specific and practical issues with our examiner. So in this section, I'm going to give you very general and brief and basic knowledge about Taiwan patent. So first, I'm going to talk about the overview of Taiwan patent. Second, what is the process of patent examination? Third, how patent right is implemented in Taiwan. And then I'm going to talk about what we have done recently in patent promotion and international cooperation. Last but not least, we will discuss the latest amendments in patent law. Let's start with general information about Taiwan patent. On this slide, here's a bit of history about Taiwan patent. Taiwan patents are protected by Patent Act, which began effective in 1949. It is also the beginning of Taiwan patent regime. The Patent Act is formulated to encourage, protect, and utilize the creation of invention, utility model, and design in order to promote industrial development. And then Taiwan has joined WTO in 2002. In order to align with the TRIPS agreement, the Act has been amended both in 1997 and 2001. All in all, the Patent Act has been amended 15 times in total. And the architecture of Patent Act is as follows. There are 5 chapters in total. The first chapter is general provisions. Second to fourth chapters are invention patent, utility model patent, and design patent. The final chapter is supplementary provisions. As you can see that each step from patent application to patent implementation has all clearly outlined rules that must be followed. So there are 3 types of patent in Taiwan. Take tablet as an example. The technology or producing method of touch panel can fall under an invention patent. The structure of separating the panel and keyboard can fall under a utility model patent. The appearance of tablet can fall under a design patent. So now we know there are 3 types of patent. Here are their definitions. Invention pertains to physically possible technical ideas. Utility model pertains to the shape or structure of an article or combination of articles. And design pertains to the visual appearance of an article, particularly computer-generated icons and graphic user interface applied to an article can also fall under a design patent. Moving on to the patent policy. For invention patent, we provide earlier protection for an application. So we will have an application laid open after 18 months from filing date. After that, applicants should request for substantive examination within 3 years from filing date. Its protect term will last for 20 years from filing date. There is no substantive examination in utility model, only formality examination, and its protect term is 10 years from filing date. Since the given patent is unclear, so anyone can request technical evaluation report for clarification. And for design patent, there is substantive examination, and its protect term is 15 years from filing date. Now move on to the element of patentability. There are three factors to determine whether the subject matter is patentable. The first step is to check industrial applicability. So what is the industrial applicability? It means the invention can possibly be made or used in industry. So we take two simple cases as example. First, in theory, in order to prevent global warming, we could use the plastic wrap to cover up entire Earth. However, it is not possible to do in real life. Therefore, it doesn't have industrial applicability. Second case is the claiming a pair of sunglasses, which claim can prevent 99% of UV rays. However, the inventor doesn't mention how to make or use this invention in their patent application. Therefore, it doesn't have the industrial applicability either. After checking if the subject matter has utility, let's look for novelty. So what is novelty? Novelty is a claim invention is considered to be novel if it is not from part of the prior art. However, there's an exception, which is called grace period. The disclosure will not be considered as a prior art in this certain period, no matter the disclosure is made by the inventor or others, intentional or unintentional. And for invention and utility model, the grace periods are 12 months. For design patent is 6 months. Finally, is inventive steps. If the invention is considered as a whole, cannot be easily accomplished by a person ordinarily skilled in the art based on the prior art, then it has inventive steps. For design pattern, this is also called creativeness. So after learning about the element of patentability, let's look at what cannot be patented. Generally speaking, the invention does not serve national interest, does not benefit to society, or violate morality, cannot be granted a patent. So for invention patent, what is not patentable? The invention involves animals, plants, and essential biological process for the production of animals or plants cannot be given a patent. However, microorganism and its method can be patented, for it is not belongs to animals or plants. Second, in order to let doctors have proper treatment of diagnosis, medication, surgical methods, and therapy of humans or animals are non-patentable. Third, the invention which violates public order or morality is non-patentable. And for utility model, it's quite straightforward. It cannot violate public order or morality. And for design pattern, what is non-patentable? The shape solely created for its function is non-patentable. And fine arts are already protected by copyright law in Taiwan, so they cannot apply for design patent. For the layout of integrated circuit, also called IC, and electronic circuits, there are already a IC layout protection law in Taiwan, so they are non-patentable for design patent. Finally, again, a design which violates public order or morality is non-patentable. So when applicants wants to file an application, these documents are required. When all the documents are well prepared, the date of submission is called the filing date. And here is the list of fees for patent application, and the fees are exchanged into PIPO for your reference. The filing fee for 3 types of patent are about 6,000 PIPO. For invention patent, if you want to request for substantive exam, it costs about 13,000 PIPO for 10 claims in one application. If there are more than 10 claims in the application, it costs about 1,500 PIPO per access claim. When the application is granted, there is certificate fee, which is about 1,800 PIPO. After the patent is granted, there is an annual fee. The patentee has to pay the fee. It is also considered as a maintenance fee. Generally, the fee will increase every 3 years from the first 10 years. And after year 10, the fee will stay the same until the patent expired. In order to increase more creativity, there is a discount policy on annual fee for certain groups of people. If a patentee is an individual, a school, or small and medium enterprise, their annual fee will be reduced. The yearly reduction for the first 3 years is about 3,000 PIPO, and from 4 to 6 years is about 7,000 PIPO. In the following slide, I'm going to share with you what is the process of patent examination. For invention patent, after an application is submitted, we will check if all the required documents are correct and correctly filled in. If there's no problem, we will have a laid open to public. After we receive the request of substantive examination, the examiner will start to examine whether the invention is patentable. If it is approved, then we will issue the certificate and the granted patent will be published. However, anyone can still request for invalidation if they object to the granted patent. If the application is rejected, applicants can request for re-examination. Finally, if applicants refuse to accept all the results, they can file an appeal or a lawsuit to these 3 higher authorities. For design patent, the process is very similar to the invention patent. However, there are 2 major differences. Number 1, after formality check, the process will automatically go to substantive examination steps. Another difference is design application will not be laid open to the public. For utility model patent, the first 2 steps are the same. However, within formality examination, we will check if the content be accepted or not. If it is approved, the certificate will issue and the granted patent will be published. Since the given patent is unclear, anyone can request technical evaluation report. And if it is rejected, applicants can file an appeal or lawsuit to these 3 higher authorities. So in this section, I'm going to introduce you how patent right is implemented in Taiwan. Patent Act is an exclusive right to prevent others from exploiting without patentee's consent. An invention can be either a product or a process. If it is a process, the patentee has the rights to its patent process itself, and the finished product made by such process. Here is a bit of history about patent infringement in Taiwan. In 2001, criminal punishment is removed in invention patent infringement. And then in 2003, criminal punishment is removed both in utility model and design patent infringement. That is to say, currently, patent infringement falls under civil remedies. So the patentee can request to court to stop or prevent infringement. They also can seek awards for patent infringement damage and demand to destroy the infringing articles, materials, or implements. In this section, I'm going to share with you what we have done recently for patent promotion and international cooperation. In order to increase intellectual property rights capacities in industrial and schools, we have different types of seminars and workshops. For example, we have seminars which focus on industry, small and medium enterprise, and startups to increase their IPR capacity. Also, we have national competitions such as patent portfolio analysis to promote IPR knowledge to public. And then we set up a patent knowledge online platform for business to offer patent-related information. And in order to stand at the forefront of the latest technology, such as quantum technology, we also put efforts into the analysis of worldwide patent trend. The analysis report will provide information to industry and assist them in realizing the critical technology and the tendency of worldwide developments. In order to encourage more creativity and interaction with industry, we will hold the innovation expos every year. And we call Taiwan Innotech Expo. We also co-host joint award ceremony with Department of Industrial Technology every year. So we participate in a series of IPR conferences with partners from across the world and continue to facilitate international and cross-strait IPR cooperation through bilateral meetings, MOU signing, examiner exchange programs, and international seminars. Before finish my presentation, I'm going to talk about what we plan to do for Patent Act in the future. In order to simplify the remedy procedure for patentees, we plan to set up the review and dispute review board to offer remedies. This new organization will be like Trial and Appeal Department in JPO and PTAB in USPTO. And this new review board will be responsible for re-examination, appeal, and invalidation in the future. So thank you very much for your attention, and I hope you have a good stay in Taiwan. Thank you.
Anyone have any questions?